page 80 is a reproduction of the rules of Bar Council of India uniform rules. Now this is an extract.
It's by mistake, it was not mentioned, so it is not a change of rule. The rule was already existing.
Can you?
All right, thank you.
Anything?
Anything?
Point out, Lordship, what's the difficulty
Yes,
here,
yes.
Lordship? Lordship, will kindly have page 80. Page 80 is the rule, reproduction of the rule.
Yes.
16. It says that returning officer shall reject the nomination paper of any person who were or are office bearers of any bar association on the date of notification of the election. Now, this was the rule. Now, after that, on 17th of January, Lordship, we'll find page 81. They sought to withdraw the rules. Now, Lordship finds what is the mandate of the election officer. The mandate which was, which the court directed was to conduct the elections and to facilitate the
Why that was withdrawn? Because the notification is as per 2023 rule. The rule that was
I'm sorry, Lordship.
Come to page 76.
23. Yeah.
Come to page 76.
Yes.
Read the first line.
Yes. Notice is hereby given under Bar Council of India rules for qualification, disqualification and produce.
आपको क्या लगता है 50,000 में क्या 2 लाख का बाइंग पावर मिल सकता है? कभी कभी होता है ना, आपको एक स्टॉक मिलता है जिसपे आपका कन्विक्शन काफी स्ट्रांग होता है, बट फंड्स आपके पास कम होते हैं। अब यहाँ पे काम आता है धन का मार्जिन ट्रेडिंग फैसिलिटी यानी MTF। इसमें आपको मिलता है 4x तक का लीवरेज ऑन 1700 प्लस स्टॉक्स। मतलब आपको देना है 25% ऑफ द मार्जिन एंड बाकी का फंडिंग आपको धन देगा। एंड द इंटरेस्ट रेट स्टार्ट फ्रॉम 12.49% पर एनम। एंड वेट, दिस इज नॉट द बेस्ट पार्ट। आप अपना पोर्टफोलियो भी प्लेज कर सकते हो इंस्टेंट मार्जिन के लिए। कुछ भी बेचने की जरूरत नहीं है। मतलब बिग अपॉर्चुनिटीज विद स्मॉल कैपिटल। Go use pledge benefit plus MTF only on Dhan.
Investments in the securities market are subject to market risk. Read all the related documents carefully before investing.
After the election was
Thank you
notified.
very much. No question to be made of this. Item 4, there is a letter circulated.
Please, Lordship.
In item 5, my lords, the Maharashtra Pollution Control Board, my lords,
Hmm.
issues us a direction to undertake the assessment, my lords, the damage assessment for an accident that had happened at our premises.
Yes.
My lords, in terms of that direction, they only give us 3 institutes where we could go and get the damage assessment from. One was NEERI, IIT or VSI. We go to VSI, and in terms of this direction, we appoint VSI for the purposes of.
So one of the expert body has assessed the damage level, sir. We are not the mathematician or we are not the super experts here.
No, my lords,
An expert body, all of you agreed that there are 3 institutions of eminence who can do it. One of them has been picked up by the tribunal, assessment has been made, losses, accident you don't deny.
No.
The molasses spread it over so many areas, spoiled the
Yes.
agricultural land, that is also an admitted fact.
My lords, may I just say, my lords, 2 points. Subsequently, my lords, there is a joint committee report of the Pollution Control Board itself, which shows that I have done the remediation work at there, my lords, in the area, my lords. I have done substantial compliance of the remediation of the accident, my lords.
Yes, sir.
Thereafter, my lords, the expert authority or the expert body goes. All I am saying is, my lords, the sampling was not in terms of section 21, my lords. Please, sorry.
Follow the guidelines and then only
No,
assess.
my lords, those guidelines also, my lords, do not ask them to take away section 21 of the Water Act, my lords.
Yes.
All I am saying.
You have been given opportunity by letter dated 23/2/2023, after the samples were collected on 5th and 6th of February,
Please.
notifying you if you wanted one of the samples to be sent to the central laboratory, you could have. You have missed the opportunity. Now,
No, that's
cannot
all I
run.
am saying is the sampling was not done in accordance with law.
it was done in accordance with law. The only thing is,
Please.
your case under 21(2) or 21(3),
Please.
you had an option to send one of the samples to the central water laboratory or the state water laboratory. You were intimated of the drawing of samples. You were intimated of the fact that this specialized body, which was chosen by you, was analyzing. You did not opt out
The water.
of that.
Show the conclusion of the body, my lords, just for a minute, my lords, just one page, my lords. Just if your lordships should kindly come to page 200, my lords. And if my lords may kindly see at the bottom of 200, they have given a finding in my favor, my lords, of the water.
The authorities will consider that.
No, my lords, but with that, my lords, they've also imposed a damage assessment of 2 crores, which will now.
Very right action. That this immediately.
Remediation being done, my lords.
Remediation and environmental damage costs are different, sir.
Well, it's because we have completed the entire remediation. If your lordships will come to page 200, at 200, the report gives a finding that the sampling has been done and it is correct, my lords, and there is no difficulty in that. The entire remediation has been mitigated, my lords. That's the finding, my lords. Only on this point I was before.
No, please, let's not, because we also know our scope of interference in the law.
Lords, may I then just request, my lords, this may not come in my way to raise the challenge because they are still considering the report on the next date of hearing. Because as far as the amount calculation of 2 crores is concerned, my lords, there
Better
is some
than
kind
you,
of an ambiguity.
better you withdraw, with the liberty to raise whatever your contention there.
That's right.
After arguing the case for some time, land council for the appellant seeks and permitted to withdraw this appeal, with liberty to raise all the contentions before the tribunal,
Please, my lords, national.
before the tribunal at an appropriate stage.
I'm so brief.
This is a larger policy decision on behalf of the state of Himachal Pradesh to decongest Shimla. No, my lords, in this case, we have a much larger premises available in a ready building in Dharamshala. There are a large number of other offices also in case of other commissions and boards which are being shifted. My lords, from the demographic aspect, people find it very difficult because the largest concentration of, my lord, the backward communities are in the Kangra district. That is also admitted by the commissioners, my lords, and in the employees' representation. And there are a handful of employees, they are not going to be moved, my lords. The class 4 employees and the lady employees, my lord, my instructions are they are not going to be moved. This particular office in Shimla is going to continue functioning as a camp office where some hearings will be held. But, my lord, there can't be a blanket stay.
This order,
Your Lordship, with regard to the fact, my lords,
the High Court will decide where publicity commission should be there, where backward class commission should be there.
Your Lordship, my humble submission is that basically they have not.
Anything you shift from just Shimla to Dharamshala, we understand that when the tribunal was shifted, this state administrative tribunal, you people will go on strike. Why not continue in Shimla? Everything continue. Shimla, there is space crunch. Dharamshala is an alternate place. Assembly also takes place. Your summer, your winter session also takes place in Dharamshala. So what is the problem if some of the offices are shifted?
It's not about some of the offices, my lords. They have also shifted some another offices. With regard to that, with regard to those offices, the Honorable High Court has not issued an order of stay, my lords. In these two matters, my lords, the Honorable High Court has taken a specific.
Was this petition filed at the instance of this landlord whose premises has been taken on rent for 22 lakhs something?
No, my lords, because
Then who is the person behind it?
Your Lordship, he is the ex-member of this aspect.
What is their problem? They are ex-member, they are not supposed to go there.
My lords, they have not even filed
And
the.
who are they to dictate an elected government that where should the office be? It is their prerogative. If you have any problem, when the next election takes place, oppose them on the ground. How this issue become justiciable?
With regard to the decongestion, my lords, there are only 11 employees, and out of 11 employees, 6 are class 4 employees, my lords. And the building has been leased out, my lords. And there is.
Building has been leased out. When they will shift, they will vacate the building.
My lords, One,
Or they will utilize the building. There is a lot of other offices
yes,
which
but-
require building.
on one hand, they are sealing the.
Why the High Court is unnecessarily indulging in these things?
Your Lordship, because basically why this relocation order has been passed on 3rd December. My Lords, in December, the new chairman was appointed. Subsequently, on 24th December, he floats this proposal for relocation. So this particular relocation order, it is on the behest and for the facilitation of the chairman, my Lords. It is this commission is working since 1998, my Lords, over there.
Are you aware of you are practicing there?
Yes, my Lords.
You
Yes.
know very well.
Yes, my Lords.
This your state administrative tribunal has been in Dharamsala, for all the times. As and when the state administrative tribunal is constituted, it is in Dharamsala only. अरे भाई आपको पता है मेरे को पता है. I was the chief justice when I abolished it.
It was circuit bench.
And
used to
since
go-
then the tribunal has not been constituted.
Circuit bench used to.
Lawyers in Dharamsala have been agitating it.
Yes, ma'am.
I went there when Palampur court was inaugurated. The lawyers were raising all the demand. Sir, we have been having at least the tribunal, you are not constituting the tribunal. I said, no, as a matter of policy, I don't want a tribunal because a litigant has to go to two platforms. First he will go to tribunal, then to High Court. So why burden the consumer of justice for that? So they agreed, they didn't go on strike, they were happily, they had some reservations, but agitation, but they never go on strike. So today, if some of the offices like winter session of the assembly is being shifted to Dharamsala, what is the problem? It is not a court that lawyers will oppose.
Your Lordship,
It is an administrative office of a commission, a backward class commission. The commission will operate, they will have to make assessment in the state. They can do it while sitting in Dharamsala, they can visit other areas also. And Dharamsala is not something in Kinnaur district or where you can say accessibility is poor.
that is why.
Dharamsala has better accessibility.
That is why, my Lords, the Honorable High Court has cautioned the state that the offices which are having a larger strength, they should be shifted rather than the offices with minuscule strength. My
High
Lords.
Court should refrain itself. We are not experts on these things.
My Lords, basically this.
High Court, we understand. Near the High Court, there is a government building. You suppose have space currents. High Court say this building is lying unutilized or underutilized. Please give it to. We require it. High Court requires for expansion of the courtrooms, expansion of the establishment or anything. Understandable that you raise your demand. How are you concerned how the backward class commission will work?
But if it is for the benefit of only one individual, my Lord, it is only for the chairman. Chairman gets appointed on 3rd December.
What is your
Immediately-
problem? Yes, why not? If the chairman wants to, as per his convenience, let it be.
My
People
lords-
will answer it in the election.
In the meanwhile, he has also communicated that a camp office will be started at the same premises. On one hand, they are assailing this order. On the other hand, they are communicating that they.
Is required in the original office, but because the demographic, Malad, overwhelming, the backward classes are from that area in Malad Kangra. So they will find the access, Malad, much better in Dharamshala.
But if they know very well, it's not so easy to, it's not so easy to travel in the remote areas in Himachal. Some of the villages still you can't go in a car. You can't go in a bus. You have to climb down. Then only you can reach there. So for the purpose of accessibility, but when we talk of access to justice, when we talk of court at the doorstep, when we talk of ease of justice, are we not these factors taken into account?
But my lords,
People who are actually backward class, don't they have a right that somebody will come to them, find out, yes, they are living in these conditions, therefore they are entitled to certain benefits of the social welfare schemes.
but with regard to that fact, my lord, from Shimla, they are doing certain other exercises with regard to the elections also.
All right. Anything else?
My lords, they have issued one communication wherein they are saying that the proposed office, which they have earlier allotted for the purpose of this backward commission, now they are saying in this communication that it will be for the camp office. So once they are opening a camp office over there, my lords, so there is no point of shifting the head.
Let them decide. It is their prerogative. They want to have a camp office, they want to have principal office, but they want to have any other office.
We will file the response.
Let us, the judiciary, we should remain aloof, away from the decisions, assuming those have been taken for political considerations, unless we find firmly that yes, such a decision is directly in the teeth of the constitutionality, constitutional philosophy, some part 3 or any other provision of the constitution.
They have-
Here we need to interfere whether it's a political decision or non-political.
My lord, they have not even filed the reply for to the Honorable High Court to take into consideration those things, my lord.
Yes.
Without even availing the elementary opportunity to
And
file.
therefore, without even taking the reply, the stay has been granted.
My lord, with regard to the communications, for the reason because as per the communication, the chairman has issued a proposal. Now he is saying, and already the state is saying they are in a financial deficit, my lords. So once on one hand, they are saying ki we are having a financial distress. On the other hand, they are shifting the offices.
Yeah, there's no further explanation.
State of Himachal Pradesh is agreed by an interlocutory order dated 9th January 2026, passed by a division bench of the Himachal Pradesh High Court, whereby shifting of the office of Himachal Pradesh State Commission for Backward Classes from Shimla to Dharamsala, from Shimla in bracket Kasumti to Dharamsala has been stayed. Next paragraph. Since the issue that arises for consideration pertains to grant of ad interim stay, it is not necessary for us to state the facts in extenso. Suffice to mention that the Himachal Pradesh State Commission for Backward Classes has been constituted for identifying the caste and communities who are entitled, who would be entitled to certain benefits meant for the backward classes. The chairperson of the commission was appointed on 3rd December 2025, followed by induction of members on 23rd December 25. The state government thereafter took a policy decision to shift the office of the commission from Shimla to Dharamsala in Vaipur district, Kangra, and to maintain a camp office in Shimla. Next paragraph. The Council for the Appellant State submits that such a decision was taken in public interest, keeping in view the demographic realities, as most of the backward classes, as the OBC population is largely residing in the lower hill districts, broadly known as Kangra and adjoining area. The shifting of commission to Dharamsala will facilitate the access to the commission, will facilitate the commission to have access to the OBC communities, most of whom live in remote rural areas. Next paragraph. In our considered opinion, in our prima facie it seems to us that shifting of the headquarters of an institute is essentially a policy matter where there is
ট্রিং ট্রিং ওমা মেসেজ মেসেজ আমি আপনার মেশোর কাকার নাতির পুতি বিয়ের কার্ড মেসেজে পাঠিয়েছি ডাউনলোড করুন আর আশীর্বাদ করুন
আমি তো তোমাকে চিনিও না তাও বিয়ের কার্ড খুলবো আমি মূর্খ নই
আরে জবাব নেই মামা ইউপিআই বলে যদি কেউ অচেনা নম্বর থেকে ফাইল বা লিংক পাঠায় তাতে ক্লিক করবেন না তাকে বলুন আমি মূর্খ নই জান আপনিও কারো টেস্ট নিয়ে দেখুন
as the matter is pending before the High Court, we do not deem it appropriate to make further observations touching the merits of the case. However, there seems to be no justification at this stage to restrain the state from shifting the office of the State Commission for Backward Classes from Shimla in bracket Kasulti to any place in Kangra district, including Dhamsala. For the reasons above stated, we allow this appeal, semicolon set aside the intent order dated 9/2026. The appellant state shall be at liberty to shift the office of the commission to Dharamsala or any other suitable place, subject to final outcome of the pending proceeding. That's paragraph. The state government or the state backward class commission may file their replies to counter affidavits within a period of 4 weeks. The writ petitions may file their rejoinder if any within 2 weeks thereafter to enable the High Court to decide the case on merits. To enable the High Court to decide the matter on merits, to finally decide the matter on merits. That's paragraph. It is clarified that the observations made herein above are for the purposes of interim stay. So the appeal stands allowed in the above terms.
Obliged.
We may be permitted to give a physical appearance in this matter. We may be permitted to give physical.
You want to file appearance? Sure.
Obliged.
Well, it's item 7. This controversy, my lord, can be traced back to a minor ammonia leak that happens in a French fry factory. My lord, as soon as the incident takes place, my lord, when the incident took place, my lessee was in fact in possession of the property. Thereafter, my lord, soon after, the authorities come and shut down the entire plant. I approached the High Court, my lord, for de-sealing of the premises.
Why didn't you go to NGT?
My lord,
Why didn't you go to NGT?
my lord, I was impleaded, my lord.
NGT proceedings were there, you got yourself impleaded. Now you open a second parallel proceeding before the High Court.
No, my lords, if I may just correct, you know, if I may just point out this alone. NGT proceedings were so motu initiated and I was only impleaded, my lord, subsequent.
Impleaded yourself, so if you had any grievance with regard to the sealing or its import, you ought to have approached the NGT. Skirting the NGT, going to the High Court, isn't it
it's today-
forum shopping?
My lords, today I only want one small relief from your lordships, my lord. I only want my right before the NGT be kept alive.
No, you want to go, please.
I'll go before the NGT, my lord. Lordship may kindly clarify that they may not be influenced by the High Court's order.
You don't require any clarification. You are not here before us to seek this
Let the
clarification.
de-sealing of-
We are not your
My
advisor.
limited submission, my lords, is that the de-sealing of the premises can be subject to the orders of the NGT. My lords, tomorrow if the NGT actually, my lord, states that the premises is, all the activities are being carried on in accordance with law, Interesting.
So, and.
I have no intention of running the unit unless and until I have the blessings of the NGT.
Sorry.
I don't want to run the unit. I only want your lordships to say that the NGT may not be influenced by the High Court's order. I'm obliged.
The problem will multiply when the other party comes.
Tomorrow if the NGT doesn't find fault with me, I'll have to file another writ petition, my lords, and get a clarification from your lordships once again.
Maybe
Is my
we
only-
rely upon that we have already, given a seal of approval of this order.
I'll leave it to your lordships. I'm obliged.
Yes, madam.
These are which matter? These are left out matters.
Yes, my lord. Some matters which remained on that last date, my lords, when my lords were pleased to grant us the absolute bail where my lords are granted interim. These are ED bail in the same matter, my lord, in DMF, wherein the predicate my lords have granted us bail. My lord, the second one is a ground of arrest that we have challenged for Ranu Sahu, and third is a DA case, my lord, in which my lords were pleased on the first day to grant us interim protection because I was already in custody for around period of 2 years.
Are these matters where you came late and we had issued notice on that day?
No, these are matters that were left over, my lords, which could not be heard because
Could not be taken. So I think we'll not be able to take a different view.
In item 9 minutes is a writ petition. 8 minutes.
Malad, I appear for ED in 8 and 8.5, Malad. Sorry, 8 and 8.1, Malad.
So do you have that old chart which we are having on the, Madam Ashwarya, do you have?
In my matters, Malad, for ED, your lordships may record my objection and I leave it to my lord.
All right, yours is item
8.1, Malad.
8.1.
Yes. 8.1 is arrest, Malad. I think there may not be too serious pressing that. That's quashing of arrest.
My lord, 8.1 is we were challenging the ground of arrest. So my lord, if bail is being granted in 8, my lord, then we will not press that.
Yes, so lordship may record that and then I.
my lords, I appear.
Dispose of 8 and 8.1. In this matter, Malad, interim bail was granted on 29th May 2025.
Where is the note? And is also this Ranu Sahu,
So 8 and 8.1 are Ranu Sahu, Malad.
the ED matter.
Yes, 8.1, they won't press. They are.
के खिलाफ में है और
So lordship may record that. And interim bail, Malad, was granted on 29th May 2025.
My lords, 8.3 is also a bail matter of a smaller player.
Come one by one. So this 3145.
My lords, that is the ED DMF bail, my lord, on which my lord, my senior is saying that she is not going to press only formal objection. The interim bail of 29.5 can be made absolute. 8.1 I will not press, my lord.
Anyway, 3145 we will allow
My lord.
in the sense that interim bail already granted is made absolute. So this will be same order as.
Yes, my lords, same orders.
There, we had earlier recorded, Mr. Raju had appeared on that occasion. So same paragraph, except that instead of Mr. Raju, Madam Masuri will appear. So 3145 is allowed to this extent,
3644 not pressed.
and which one you don't press?
My lord, 3644, my lord, it was in the same matter, ground of arrest we had challenged in the High Court, my lord, say SLP against that one.
No, 3644.
Yes, my lords.
You don't
We will not press, my lord, because my lords have granted us bail, my lords.
say, in view of the fact that while separate order of even date, the petitioner has been released on bail.
My lords.
Formal and counsel for the petitioner does not press this petition.
Most of
So
them.
accordingly, dismiss has not pressed for.
Wait minutes.
So now we are left with, at serial number 8, there are two matters only.
No, my lords, there are more.
No, it's 8.2 is a writ petition filed by Ranu Sahu, my lords. We have, no notice has been issued, we have not been served, my lords, 8.2.
8.2 is a writ petition, my lord, because I was arrested 3 times consecutively. Whenever my lords used to give us.
We can't issue omnibus direction, it will be very difficult. Tomorrow, if you come, assuming, we are not saying about you, but assuming a person, he says, grant me a preemptory bail order, and he commits murder, the authority will be helpless. They will keep on watching there because the Supreme Court has said that, no, we can't arrest you. So it all depends upon, we have been rescuing you, as and when occasion arises.
My lord, I bow down to that. We only came, my lord, after 2 years, when my lord on 3/3/2025, in a matter where I was under arrest for around 1 year, 8 months, my lord granted us bail. ED on the same day moved a production, my lord, and then sought my arrest. It is only then, my lords, that because it was becoming something in perpetuity, my lord, because I was getting bail by my lords were kind enough to grant us bail. The next day or the same day, either EOW or ED was coming and arresting us, my
But it
lord.
seems from the variety of cases against you by ED, by Anti-Corruption Bureau, by this.
My lords have been extremely kind to us, my lords.
I think my
Same
colleague should
property.
choose between not pressing or dismissal.
No, my lords, it's writ, my lord. The same issue, same properties is being circulated in all cases, my lord. In DMA.
Maybe obviously because if you have, their allegation ultimately is what?
State.
That you being an IAS officer, you misuse your position, abused your power and earned illicit, right, benefits, maybe through gratification, maybe through shareholding, maybe whatever. These are all set of allegations subject to trial. And you have parked that money in buying some property in your name, buying property in the name of your brother or your family members. So ultimately it is the Indian currency only. They are not talking that you convert it into dollars. It's the same property, same set of allegations.
I am in my lord's hands in this, my lord. My lords may decide it as these are issues that we have raised, my lord. One only thing, my lord, that there were DMs after me, there are DMs before me. Nobody has been investigated also, my lord.
Withdraw this petition saying that you will approach the appropriate form as and when occasion arises.
Permit us to come back also, my lords, if they file another case.
You have been, there is no question of coming back. You have never gone out of the court. You have always been here in one or the other matter. You are always, any litigant who is aggrieved by of an action or of whose liberty has been supposed compromised, we never say our doors are closed. You are always,
I leave it to my
will
lord.
consider act per law. After arguing the case for some time, learned counsel for the petitioner does not press this petition. As according to him, he will approach the appropriate form as and when occasion arises.
My lord.
Ordered accordingly.
My lord,
Now, any other item?
8.3, my
My
lord.
lords, 8.4. 8.4.
8.4.
8.4 is a matter where anticipatory bail
Yes, approved.
of Ranu Sahu, my lords. My lords were pleased to grant her interim bail on 29/5.
that
And
in
Bureau matter.
yes, my lords, in DA case.
So here also you make the same,
My lord.
this is also made absolute on the same.
I'm most of that.
My lords, 8.3 also is the same. It's a Manoj Kumar Dwivedi. He's a smaller player.
Yeah, my
He may also be granted.
8.3 is.
8.3
from Manoj
not
Kumar
six.
Dwivedi.
Yes, my lords, Manoj Kumar
So
Dwivedi.
that's also same.
He was granted.
I'm 8.3, I don't know.
8.3 is an ED matter,
ED
Lord.
matter.
Mr. S.V. Raju appears.
ED matter, you are right. ED
Yes.
matter.
In that matter, he had asked me to take a
He
passport.
is not better than,
I get it. The interim order is there already.
the same order, huh? All right. ये ईडी का मैटर होगा, इसमें मैडम ऐश्वर्या का इनका साथ में ही इज अपीयरिंग इंडिपेंडेंटली. Raju sir.
Yes, yes, Mr.
Raju along with this
Yes.
young man. 8.5 is also there.
Malab 8.5,
Vedram,
he was not arrested during investigation. He's an excise officer. And my lords have granted bail.
Excise officers order.
Malab, while order dated 29/8/2025. Malab, he was not arrested during investigation and was granted bail by this court, interim bail. Yes, Malab, interim bail.
release now.
Yes, Malab.
Say, the
Same. They're verifying them.
no, this is Vedram Lhare, na?
Laren.
So we had passed an order on 23rd September 25. Meanwhile,
Make it absolute.
so we made,
Yeah, absolutely.
so for the reasons recorded in our order dated so and so, passed on so and so day, the interim order dated 23rd September 25 is made absolute on the same terms and conditions which we have imposed in the similarly, in the case of similarly placed petitioners co-accused. All right, that is also finished. Any other matter?
Malab, item 9.
Item 9.
9, my lords, I'm seeking 2 weeks' time to file a rejoinder. Their counter has come in only on Friday.
Malab, this is
2
the
weeks
same
after that.
matter as
Hold
Ranu
on,
Sahu.
hold on, my lords, they filed a counter affidavit. I'll come back.
This is same. He's
Should not be arrested.
seeking similar omnibus prayer, Malab.
I want to file my rejoinder, my lords. I don't know why should there be a problem with that.
A similar
Lordships
matter
have
has
issued
been.
notice, my lords.
Prayers are
It takes
similar
them
to
2
that
weeks to
as.
come back in my this thing, my lords. They filed a counter on Friday.
You can approach the appropriate.
No, my lords, I've already approached the appropriate forum. I've come not in a direct 32 here. I've come against a 226 dismissal. So please give me 2 weeks, my lords. I'll come back in my rejoinder also. There are some new facts that they've taken. We'll respond back. So after 2 weeks, if your lordships allow.
Bail or,
My lords, my
the
application
same way that
is rejecting.
Used under Article 30.
article.
Alternative remedy one, and then second saying that you should have either filed a quashing or you should have filed a anticipatory bail. Now, neither of them in my case will apply, my lords, and I'll point out why. I'm just taking 2 weeks' time, my lords, if your lordships will accommodate me only for 2 weeks.
So let me take up on.
Great.
What about 10?
My lords, in item 10, I am seeking a pass over, my lord. Item 10, I am seeking pass over.
Small player.
Maya Warrior. She can also be granted. He is there for the ED.
ED Lordship, I am appearing. I am led by Mr. Raju.
So she is a very small player as compared to.
Yes,
the-
but Lordship, if sees the prayer B does not exist because prayer B was not there in the special court's order. So prayer B does, because Lordship, the
স্নানের সময় কোন পিএইচ 5.5 আপনার পছন্দ?
Himalaya Gentle Baby
court has not imposed any condition that is pleaded in prayer B of the IA. So prayer A, I leave it to your Lordship if Lordship wishes, but prayer B doesn't.
More conditions to be imposed, sir.
That all in very stringent conditions we impose.
Yes, but Lordship, I am saying,
Those condition will apply here also.
yes, but Lordship, if only comes to page 5. Prayer B says, direct the petitioner to report to the concerned police station, EOW, ACB, Raipur or any other police station once a month or fortnight. That condition was not imposed by the special court. So the condition that she is asking for waiver of is not in existence. That's what I'm pointing out.
Now, what is prayer number 5?
Prayer, page 5, Lordship comes to the IA for modification of bail condition.
Prayer B.
What is it?
There is an IA.
Report to the concerned police station.
Yes, this condition was never imposed by the special court.
This was never imposed, so this is infructuous. No, sir.
Yes. Lordship will find the conditions that were imposed in page 13.
My lords,
No, but where is this condition imposed by us in the order of 6th of October?
Yes, Supreme Court by order dated 6th of October said conditions will be imposed by the trial court. Lordship will see that in page 9 of the same IA.
The Lordship will see the conditions which were actually imposed by the special court in page 13.
No, but 6th of October is very short order by us.
13, 14 is of conditions imposed.
These are condition imposed by the trial court.
Trial,
Yes.
there is no condition of meeting the investigating officer.
Reporting. Which is the condition this one?
Sir, stay outside, stay away, submit affidavit, surrender his passport, and so on, so on.
Yes.
My lords, eyes.
Mechanically it has come.
For the enforcement, after hearing Shri Raju along with so and so on behalf of the enforcement directorate, from the interim order dated 6th October 2025 is made absolute, subject to the same terms and conditions as have been imposed by the special court, special judge.
Special Judge Dhan Sadan
This place,
6th Additional Session Judge Raipur, Chhattisgarh.
Special Judge in bracket Money Laundry Act, 6th Additional Session Judge Raipur, wide order dated so and so.
7/10/2025.
70,
Order dated so and so.
17, 20.
Grateful, Lords.
Please, sir.
Now your matters are over, which Chhattisgarh.
One item is there.
Please, Lordship.
14
is still left.
14? Okay, we'll see, just in 2 minutes we are reaching the 5 minutes. Item 11?
11, I must at the outset apologize. My counter was filed a little late, but I have copies, my lord. I filed a counter for the state.
In item 11?
11.
For the state of Maharashtra state flat. Counter affidavit has been filed, but the same is not attached to the, is not tagged with the paper book. Registered to do the needful. Next Monday? Next Monday.
Next one, I'm.
Post the matter next Monday.
Very. I'm grateful, my lord.
My lord, one request, my lord, if possible, may be kept on 18th. Monday, 16th. 18th is if possible.
All right, sir, we will comply with your. Yes.
Item 12, my lords.
Item 12.
12 minutes. Charge sheet was laid, my lord, in the year 2023. I appeared before the court, coming up after notice, my lord, I appeared before the court, executed the bond. Subsequently, on an application filed by defective complainant, one more charge was added. Therefore, my lord, my bail bond was cancelled. I moved for anticipatory bail. Sessions Court granted anticipatory bail. The Honorable High Court reversed it. So against which I am there, 2023, my lords. Violation of trademark.
Your anticipatory bail was cancelled. We have stayed that order.
Yes, ma'am.
He wants to make it absolute.
Granted.
My lord, they have not only misused my company's name, they've been selling poison to the public. High Court in its order, my lord, High Court has clearly said, where is that order? That is an, page number 198 of their SLP, my lord. High Court says that when they went for testing, they were absolutely unsafe for human consumption. My lord,
That's right, that for that, whatever the trial will take place, and if they are found guilty, obviously they will face the.
I say, my lord,
consequences.
the bail was granted only on the ground that overlooking section 467. They said all the offences are, I apologize.
The best course for the state is that, the powers are very well there. They can seal the premises, they can close the premises where it is found that what is being manufactured is basically a poisonous substance. They can always do that. There are other provisions. That does not mean that criminal case will not continue. Criminal case will also continue. But for that preventive measure, they can take other steps.
My lord, High Court has said that you surrender and apply for regular bail. They should-
State, and we hope that the state will.
Madam, I'm pretty for a state, my lord. My only the legal submission is that once they have appeared and took regular bail, then the question of anticipatory bill is not there. They should go and take the regular bail. Who's going to stop?
Cancelled, therefore we.
Well, we have heard and senior counsels to counsel for the parties. Party. It seems to us that there do not exist sufficient and valid grounds on the basis of which the High Court could recall the order granting anticipatory bail to the petitioner. So, आपको leave करके कर देना कि order satisfied करना है. Consequently, the appeal is allowed. The impugned order dated 17 December 25 is satisfied. It is directed that the appellant shall continue on bail, subject to same terms and conditions as already imposed during the pendency of the trial. Next paragraph. It is however clarified that the granting of anticipatory bail shall not be an impediment for the competent authority to take other preventive measures against the industrial unit if it is found that the product contains any poisonous or unhealthy substance. So we have clarified that. Now we can.
Take it. No problem. Black.
Safety law को करना, food safety law में करना,
So under the
FSSAI.
describe the authority.
Come from that sector. Next year, producing, that's why I got that. Okay.
Please, my lords. My lords, please, my lords. My lords, despite this vicarious liability, my lords, I just explained that I've already undergone 9 months, my lords. If it is considered under section 26, that is violation of conditions of license, the maximum punishment.
Who is opposing from the respondent?
Don't argue that, sir. Don't argue all that drug and cosmetics.
Please, my lords, I'll argue on
With
merits.
regard to your complicity.
Kind of medicine your partner is recommending, it is not under the drug and cosmetic.
Yes, ma'am.
Very easy to see.
No, I'm talking about 26 only. But NDP is 26. But on that, my lords, I'm not leaving that for the moment. On merits, my lords.
No, we
Who is
followed
appealing
the
for the
sub-
response? Service they could.
So Dr.
Malhotra-
Malhotra had
Yes, he is true, my lords. And he was running. I'm only a silent partner.
But we are surprised doctors are doing.
But my lords, your lordship, kindly see, there was no animus because in fact, they are searched.
In Punjab,
It's a malice. It has to be.
drug mafia includes.
Yes, it's a mafia.
People are making lucrative money, the doctors, the so-called industrialists, the police, and so many people are hand in glove. Unfortunately,
But one interesting thing, my lords, why this Malhotra might have done it, because the search in the pharmacy took place on 28th. Then thereafter, the search here took place on 2nd, next month. So So even knowing that the search took place in the pharmacy, these people thought that this is nothing illegal here. Otherwise, they would have removed it. If they had some idea, Malhotra on paper, no person with a reasonable sense will not order for some.
Let us not open our mouth because it's for the prosecutor to move
Absolutely.
the case.
Absolutely.
But this was under the cover of using it as a medication. They were dealing with a Schedule H drug for which even the hospital does not have the license.
Deeply obliged. Return of some early date may be given.
Trustee also.
Deeply obliged.
Notice देना. Notice देना है ऊपर देखिए.
पहला फर्दर वाला है सर
Yeah.
14 है ना
Lordship, in item 14. But not point 1 and point.
but for the state.
I'm there in one. Password? No, not a password. Not a password.
14 का नोट है कैंसिलेशन
Well,
ये वो दूसरे वाला है सर ना 14 14 वाला सर ये ग्राउंड्स पे बेल मिली है सर डिटेल ऑर्डर है सर वो कहते हैं कि नोटिस इशू कर दो सर नोटिस इशू कर दो ये बोलेंगे ना उसको स्टेट ऑफ छत्तीसगढ़
We'll take up this matter after some days.
At least notice may be issued.
no, my lord, I have serious objections to this. This was argued at great length. Your lordship will see the orders. Every contention has been considered.
Well, that's my whole case. I'll point out in two.
No, I'll also point out.
Notice again delay, my lord. At least
No.
it should be issued. I'll point out that none of my arguments
My lord.
have been considered. And my lord, there are some propositions of law, with the greatest respect to learned judge, my lord, which are not tenable.
It's a very
Your,
detailed order.
your lordship will see.
Detailed
50
order.
pages.
It's not a detailed order.
Can't be not a regular.
How can-
Against a bail order. It should be a ground.
My
for
lord, it is
cancellation.
not a detailed
So
order.
now every order will come on an appeal like this.
59 pages of narration of facts.
Coming in every case, my lord, this is.
Every aspect was considered, my lord, and at length for many days.
But I thought it's my petition, my lord. I should be.
We are opposing your petition.
Of course.
By saying this is, your lordship has done, my lord, so many of these cases.
Today, for some
Well,
reason,
this
we are not saying anything for today for some reason.
Very well.
We'll take up this matter after a week or so.
Yes.
After 2 weeks, my lord, I have some difficulty. After 2 weeks.
My lord, because this man has been released on bail, a vital witness is not attending anymore.
My lord, that
His
in fact
his
is an
best
issue
friend
which
Manav,
needs to
a
be.
chap called Manav Saxena. Well, I'll point out what kind of.
You can bring those, so if any subsequent events.
Yes.
Because 2nd January means now more than 1 month.
Yes, we will bring
If
that.
there are any visible subsequent events, you can place on report. Meanwhile.
One of the main grounds that vitiates it is, my lord, that this man's name was not mentioned in the FIR, therefore it should be granted.
May I draw your lordship's attention, my lord, Chief Justice. My lord, in 14.2, this is that lady Soumya Chaurasia. Soumya Chaurasia. My lord, she has been granted interim bail in a large number of cases by your lordship. My lord. She has spent 2.5 years in jail in and out. Your lordship asked her to stay out of the state. Now they have registered a fresh FIR in December this year, again relying upon material blood of 2019, and she is arrested. I am requesting.
No, but December is much before we pass this order, last order.
Not fresh FIR.
December means much before.
No, I'm. My lord, arrest is in December. She has been arrested now in December. My lord, I am praying for interim bail. My lord, she has been granted interim bail by your lordship over the last 2 years.
But file some petition, Mr. Rowe.
We have filed. It is listed 14.2, my lord. Notice was issued by your lordship.
14.2 and 14.3, Mr. S.V. Raju appears as taking a passover.
In that liquor case. This is ED liquor.
14.1 and 14.2.
No, one is unrelated.
This is the 6th time she is arrested. 5 times I have got.
14.2 is a writ petition under 32.
Yes. But I am saying this is not a evergreening of arrest. How many times, my lord? 22, 24, 25, 6 times the lordship granted her bail.
It's a writ petition. Anyway, there is no requirement to serve.
My lord,
Pick up your matter within a week. You file a petition there. The instant repetition under Article 32 has been filed
Lordships have granted.
by the petitioner
Notice issue.
questioning the vires of Section 44 of PMLA. However, we find that in substance, the petitioner is seeking her release on bail in a matter in which she has been arrested on, what is the date of arrest? On 16 December 25. In relation to the liquor scam, has been arrested by Directorate of Enforcement in relation to liquor scam. Since the primary relief sought by the petitioner pertains to grant of bail, we relegate her to approach the High Court of Chhattisgarh. It may be Chhattisgarh. The petitioner, for my so advice, may file a petition.
তাহলে ওর অ্যাস্ট্রোনট হবার ফাইন্যান্সিয়াল প্ল্যানিং হয়ে গেছে তো ইনভেস্টমেন্ট শুরু তো করে দিয়েছে আর এই সময়ের মধ্যে যদি তোর কিছু হয়ে যায় তাহলে তাই তো আইসিআইসিআই ব্লু স্মার্ট কিট 360 যা বাচ্চার ভবিষ্যতের জন্য দেয় গ্যারান্টেড অ্যামাউন্ট আর যদি তোর কিছু হয়ে যায় তাহলে বাকি সব প্রিমিয়াম কোম্পানিই দেবে আর প্ল্যান চলতেই থাকবে
And other points. Disposal.
14 and 14.1.
Lord, she has also been arrested by EOW now. So, my lord, your lordships, my lord, observation may apply, my lord, there also.
She has been arrested by now, by EOW.
My lord, this was ED, what your lordships have dictated.
Instead of ED, then.
This was ED. Now, my lord, after that, she has been arrested, my lord, by EOW on 2nd of January 26.
We think that the petitioner has been further arrested in another case by
EOW,
Chhattisgarh. Economic
offences wing.
So and so. Then the petition may apply in both the matters.
Correct.
Then
Very good.
So my lord is placing 14 and 14.1 together on a separate date?
There's no connection, my lord, please.
No, there's no connection, I agree.
You are going to get-
14.1 was in relation to the evergreening of complaints, my lord, again and again. Without seeking permission of the court, there was a point of law in that your lordship had.
No, this is the first time I've heard of accused who themselves evergreen, now accusing the state of evergreen.
That is ED.
Yes.
That's ED, sir. You're not in that.
No, no, it's, therefore.
in
Evergreen.
14 and 41, we can take
Yes.
together.
Can it be after 2 weeks, bro?
After 2 weeks or 10 days, give a date.
So grateful.
Both matters are 14 as well?
Both.
14 and 14.1 is filed by you.
Yes, bro.
That is ED matter.
That is the ED matter.
That is not your case, Mr.
That's
Jatnai.
14.1, but your lordship may keep them on separate dates.
No, 14 and 14, but don't tag them. Don't
tag,
mention as
that's
14.
that's
all right,
14 or 15 like this.
Yes.
And be tagged and listed separately, but on the same day.
So grateful.
Obliged.
Grateful, Lordship.
Please, my lord. Lord, pursuant to your lordship's order, my lord, of 27th of January, there is a fact-finding report, my lord, that the loss caused is only 3 lakh of rupees. And what the penalty sought to be imposed, my lord, is 12 lakhs, my lord. We leave it to your lordships, my lord.
This item 15, are you referring to?
What kindly have your lordship's order, my lord, of 27th of January 26, my lord. Last order. Issue notice, meanwhile, interim anticipatory bail is extended. However, Chief Secretary are directed to submit a tentative fact-finding report with respect to the loss caused to the state revenue, including in terms of the value of the illicit transported minerals, which is attributed to the petitioner. It is made clear the continuation of the bail will depend upon it.
Well, is there any report filed?
Yes, Lord, we filed that report, Lord. If your lordship has the fact-finding report, he, in this span of 2 months, Lord, he extracted about 4,314 tons of illegally mined this thing, minerals. And the total penalty which the state is to recover from him is about 12 lakh.
According to you, the loss is 12 lakh.
12 lakhs, yes.
7,000.
This is the penalty, Lord, but this is apart from
Loss
the
is
fact.
3 lakhs. Loss is 3 lakhs, my lord. Penalty is 4 times, my lord, the loss. That your lordship will
You
get.
can afford to deposit without prejudice to your rights.
Lord, this is only
Lord,
small.
this
This is
man is a
small time, my
habitual
lord.
offender.
This is a
Your lordships-
transporter, my
There-
lord. Get him.
There is sometime a presumption, the presumption is that the litigant who can afford to engage Mr. Devdutt Kamath
My lord, I'm sorry.
seems to be having capacity enough to deposit this fine amount.
Lord, he's
Lord,
a
the laws-
repeat offender, my lord. Earlier also, a penalty of 90 lakhs was imposed on him, my lord. Not only that, he was absconding. We had to issue
That
proclamation
excuse is
notices.
there. Nobody
He's a
questions.
flight risk as well, my lord. So I was only wondering, my lord, whether we lordships would ask him
Said in
to,
the
now that the charge
affidavit.
sheet has been filed,
Say
and the charge sheet discloses, my lord,
Huh?
the charge sheet now discloses that he used fake Ravanna papers, my lord, to transport.
Lord,
this.
I have lot to say on
And-
the charge sheet. After give me a.
No, no, charge sheet has been filed. now.
Charge sheet
Yes,
has
my
been
lord, charge
filed.
sheet is filed.
So the petitioner was denied pre-arrest bail, anticipatory bail by the High Court of Uttarakhand. While the impugned order dated, leave granted, the appellant was denied anticipatory bail by the High Court of.
No, he was granted anticipatory bail, but only a
Only
time.
for
He
2
was
weeks,
granted
madam.
anticipatory bail,
It was
but only for
limited-
15 days, so that he could seek regular bail. That was the bail. That's the
That
impugned
is
order.
completely
The-
contrary to
like,
lordship's judgment.
The, say like this, the High Court of Uttarakhand, while the impugned order dated 30th December 2025, granted anticipatory bail to the appellant in case number so and so. However, limited the operation of that protection to the extent that limited the operation of that protection for a period of 15 days, meanwhile granting liberty to the appellant to approach the jurisdictional court for grant of regular bail. The aggrieved appellant has approached this court. Then say on 27th January 2026, the following order is announced. Then say in reference thereto, a fact-finding report has been submitted by the authorities, according to which the appellant is alleged to have caused total revenue loss of rupees 12,07,927 only.
Lord, 3 lakhs is the loss. Penalty, they say, comes to 12 lakhs, my lord. Loss is only 3 lakhs.
So has caused loss of 3 lakh to the revenue.
No, that is not
along with
our
the
report.
penalty of rupees 12 lakhs only.
Page 6, my lord, of the.
Next paragraph. It is not in dispute that investigation is complete and charge sheet has been filed. So that being so, we are of the view that the appellant can be allowed to continue on pre-arrest bail, subject to however is depositing the amount tentatively levied, the amount tentatively levied. The fine and penalty, subject to his deposit of the levied amount of fine and penalty. The appellant will deposit the requisite amount within 2 weeks, without prejudice to the rights of the parties.
Yes, ma'am.
Next paragraph. The appellant shall be at liberty to challenge the levy of penalty or the levy of fine or the penalty before an appropriate form in accordance with law. Next paragraph. Similarly, the deposit of fine or penalty shall not absolve or exonerate the appellant from the penal consequences, if any, and so all these issues shall be, if any, should be, and thus the trial court will proceed against in accordance with law. The trial court shall proceed in accordance with the law.
Lord, the conditions
So your
imposed,
lordships may
the conditions imposed by the High Court will continue, Lord. So your lordships may, the conditions imposed by the High Court for grant of bail, those will stand incorporated by your lordship's order as well, Lord.
The appeal
On the
is
same
allowed
condition.
before one impugned order of the High Court is set aside.
Lord, the only request is whatever your lordships have said,
Is allowed in about terms.
whatever your lordships have said, my lord, But the lordships may say that not affect the merits of the case, my lord, because ultimately
Goes without saying.
Clarified that we have not expressed any opinion on merits of the case.
extremely grateful.
I'm grateful.
Item 16.
May it please, Mr. Lord said, directed me to inquire about the antecedent of this, the petition. Well, there are none.
No antecedent.
That was the only.
No antecedent. He got money in respect to online fraud, but
The appellant is agreed by order dated 11/12/25 past 12. The High Court of Chhattisgarh at Bilaspur, declining him bail in FIR number 157/2025, registered at Police Station Raipur under section 111, 317 in bracket 2 and 317 in bracket 4, 317 in bracket 5 of BNS 2023. The appellant was arrested on 6/10/2025. The allegations are that during the period 26 June 2025 to 6 July 2025, the appellants co-accused, Vishal Bekra, operated multiple bank accounts through which online fraudulent transactions aggregating approximately rupees 9.45 lakhs were received. The appellant is alleged to have assisted the above named co-accused by providing a mule account, and he received a share of the proceeds in cash. Next paragraph. Having regard to the nature of allegation and the period spent by the appellant in custody, or without expressing any opinion on merits, the instant appeal is allowed. The influence of the High Court is satisfied, and the appellant is directed to be released on bail, subject to his finishing bail bond to settle the trial. He is to be back to the bail appeal. You are still NFP?
No, my lords, I'm in custody, my lords.
No. If suppose you like the jail premises or the jail atmosphere environment, then we can dismiss the petition. We can allow you to stay in jail if you want. Otherwise, we have by mistake granted bail to you. You want to be on bail or you don't want?
My lords, I want bail, my lords.
Then you should go by with a smiling face from court. Why you are so showing as if you are under depression?
Okay.
Thank you, young lady. Thank you. Item 18.
My lord, item 17, my lord.
Just
17 minutes.
My lord, 17, my lord. I am praying for bail, my lord.
70? Thank you. Or 17 also?
Yes, my lord.
Oh, you are the main accused. This is my main
He's
accused.
the main accused, my lord.
My lord, I am. My lord,
इसको bail दे दो.
my lord,
अभी तो छोटी मोटी चोरी केस है.
The child, same reasons, my lord.
my lord has granted me bail.
अरे दे दी भैया बेल दे दी. क्या साहब आपसे डर लगता है पहले. Item 18.
My lord, bail was denied to me while granting bail to others. For me, my lord, bail was denied because I happen to be closely related to A7. So he is upcoming, he applied for anticipated bail to be dismissed. That is the only reason given. Your Honor, kindly come to pay 31. Long incarceration.
the main.
How much you have made money, sir? As per the allegation?
732 crores.
Only.
A7 is the shell company. Owner
Your
of
Honor,
the
kindly come to page 31, my lord.
not
But long incarceration is the only ground.
9 months only.
My lord,
9
10 months now.
only.
Now 10 months, almost 10 months.
For 700 crores, 9 months. Look at
That is
eminent
what they say. I do not want to
position.
go into the merits of the matter now.
Look at the eminent position and the seat of power you have enjoyed. there is a direct nexus between the allegations attributed to you and the position you held for a long time.
But I will,
And you are not an ordinary and small kind of person.
but
And after investigation, there are definite allegations against you of taking a huge amount of bribe and
but I will not,
visible in your accounts or in your non-sources.
but at this stage, I do not want to go into the merits of the matter, Murad. At this stage, Murad, I will argue the matter on merits when they file their counter. No, Murad, for the present, Murad, I would submit. All the other accused, most of the accused similarly placed have been granted bail on the same ground.
We have also granted bail, we are aware, but not, those were very, very small fries.
No, Murad, same thing, Murad, same. You also kindly see, so far as accused number 34 is concerned with the similar or graver allegations. All. Murad, almost Murad, all Murad, according to the case, all acted,
The order, page 31 of the order.
not only me. Murad, the others also, Murad, similarly placed, they have been granted bail. Yes, Murad. Yes, Murad. But so far accused number 1 is concerned, closely related to Murad, determining factor, closely related to A7, who is absconding now. Another influential supervisory role, that's all. Murad, for the next man, Murad, investigation substantially complete, no direct recovery, risk of absconding or tampering not shown, role more facilitative than controlling. Then next man, Murad. Investigation complete, co-accused with similar or graver allegations granted bail, prolonged detention would be pre-trial punishment. Same. The next man, charge.
You are the central conspirator, first of all.
No,
Central conspirator,
you are asking me-
orchestrated liquor policy, influenced obvious allocations, promoted blue-eyed brands,
you not kindly come to.
collected
I will-
kickbacks
I
of
will-
50 to 60 crores.
You not kindly come to Murad's page, Murad, paragraph 44, page 24. Murad, the allegations against me have been, Murad, almost similar allegations against others also. Murad, charge sheet has been laid, I have been in prison for Murad 10 months.
No,
You not kindly say.
allegation against him is 732 crores.
That's right. You not kindly come to paragraph 44, Murad, of the order, page 24.
Nagamothu,
My lord.
the shell company in which 750 crore was parked, as per paragraph 45 you indicated,
Yes.
is in your direct control through A7.
No.
This is the prosecution case. Now, if you accept that, you stand clearly on a different footing to A6, A34.
I will show Murad, the other accused for whom bail was granted. Murad, the graver offences than me. Murad, they are also.
Wait for some time, Mr.
Murad, for the present, Murad, my humble submission would be Murad. Murad, let them file counter. Murad, I will take your lordship, Murad, and place records also to show that absolutely, Murad, there is nothing against me, Murad, and these allegations are very minor.
At best, you can make out a case for cancellation of bail granted to some others, but that will not help you in getting bail.
Murad, Murad, that matter is pending before this honorable court. Your Honor, kindly tag this along with that. Your Honor, kindly see, Murad, in respect of some other accused, Murad, bail was granted, challenged before the court, pending, your lordship have granted stay of that. High Court cancelled, Murad, your lordship have granted stay. That is also pending before your lordship.
No, those were.
That matters been disposed of.
They have disposed of.
Right, there was question of statutory bail. We said that without going into that question, they will remain on interim bail and the issue will be decided on merits.
Well, that's, if your lordships, Murad, decide to go into the merits of the matter, Murad, I may need some time. Murad, kindly have it, Murad, this Friday. Murad, I will argue elaborately, Murad. I do not want to waste the time of this on today. Murad, kindly have it on Friday. I will argue the matter elaborately, Murad, and demonstrate.
How does it matter, Mr. Nagmuthu?
My lord.
Monday or Friday, how does it matter? You can argue. Bail at this stage.
Murad, I got some.
If you argue on merits, you are welcome. We can't stop. But please, you will not invite any observations from us on merits also. Today, we are only simply to say, at this stage, we are not inclined. After the examination of some of the vital witnesses who have direct bearing on your accusation against you, liberty to apply afresh before the High Court.
Murad, your Honor, kindly At least will not kindly have it tomorrow, I will argue the matter elaborately. Will not kindly, for my sake, will not kindly have it tomorrow, I will argue the matter elaborately. Tomorrow, my lord, at least. Or subject to my lord's convenience any day. my lord. Any day subject to my lord's convenience. Tomorrow is inconvenient for your lordships. Will not kindly have it any day. I will argue the matter elaborately. Any day, I am not asking for any.
Now,
Any day, my lord. Friday, this Friday, my lord, subject to my.
before Friday, my lord, Friday.
Any day, my lord, subject to my lord's convenience. Any day.
Before Friday, you tell us one word. Day after, Wednesday.
Tomorrow, my lord, tomorrow, my lord. Tomorrow, my lord.
Day after we are arguing.
Day after tomorrow, I'm not here.
On Thursday?
Thursday.
All right, Thursday.
Thursday. Good. Good.
No. Yeah, that's it.
Now, Lord, Lord, this is a case, Lord, where a closure is ordered of a chemical factory. Now, Lord, this is not a case where the factory is deficient in any manner. We are functioning for 10 years. We are fully compliant. The allegation is that, Lord, we have to dispose of spent hydrochloride acid, which we use for manufacturing, Lord, an intermediary product.
There, Mr. Rodri, deputy.
Discharging the acid in Narmada Canal.
In the Narmada Canal.
So what has happened is this, Lord. By the Gujarat Pollution Board, I can't use any truck I like. I have been using an approved vendor Lord, for 5 years. They have made more than 500 trips. There has never been a problem. It has to be disposed of in that man's factory, Lord. That's how the hazardous rules provide. Now, Lord, I accept what has happened. Apparently, this driver on this trip did not take, Lord, the product to the factory concerned for disposal, which has been going on. Apparently, Lord, the allegation is he disposed of in a canal, etc. Now, if that is so, Lord, there can be some penalty. The penalty can't be that you, Lord, throw the baby with the bathwater.
No, we are not saying that.
What wrong has I done? I have chosen, Lord, a vendor approved by you. The driver went elsewhere.
The point is, Mr. Rodri, that whatever mechanism you had for disposal of
yes,
that has been found to be faulty.
No.
It is faulty because they don't have control. Once the material, this liquid goes from your factory premises
to another factory. Yes.
You don't have any physical control on the driver because you have hired an agency. And assuming this truck is caught, we do not know how many trucks went unnoticed.
I'll answer that. It can't be because the actual live movement of a truck approved vendor under the hazard rules is on a website which is alive and
Mr. Rodri, please see.
It is GPS enabled.
It's a question of life for millions of people.
I agree. I can show you. Show me.
Only source of drinking water in that space.
I am not saying no. I am saying, Milord, if it has happened, the remedy can't be closure.
We are not saying that. Your remedy will be that you will have to satisfy the NGT that what kind of preventive measure you will take. It will be a scheme.
Show me that. Show me that movement. Perfectly right. I will show you, my lord, that there is a live GPS of every truck with this number moving, my lord, on a screen, going from A to B. When I saw it myself, there was some diversion, my lord, of that truck. That is, my lord, this is how it is done by GPS.
This you can show to the NGT also.
No, I only wanted to say, my lord, this man may be remiss. This is how, my lord, it goes. This man may be remiss. 1 out of 500, my lord, trucks may be remiss. I am not saying no. But the remedy can't be to order a closure of the factory. You may have some penalty, something. I can understand.
We are not saying at all that what should be the proportionate person.
Correct.
You are entitled to argue on the doctrine of proportionality that you can, but you can argue it before NGT.
Proportionality, I agree, my lord. Proportionality is if I have committed something wrong, my lord, I have chosen a vendor, what else can I do?
Under the hazardous rules, Mr. Rodgi, it is product liability.
Correct, but approved by them.
Argument.
What else can a man do?
Order.
My lord, some penalty, yes, but
The Honorable Chief Justice indicated to you that it is a question maybe of proportionality in the embargo or the interdict.
if I am remiss,
That is to be examined by NGT.
Once you will submit a scheme to the NGT, that yes, this mistake or lapse has happened, but to prevent it, that and to ensure that there is no violation in
Right.
future, this is my scheme.
and this is what I am doing, my lord, for the last 10 years.
The tribunal will consider that. scheme.
Only one more request. My lord, now the order has come. That day the order wasn't there when he mentioned, my lord. The order, my lord, of the High Court has come now. Have a look at that, see the last portion. I want to make one submission there. I filed that order separately, my lord, it wasn't there.
It's impugned.
It is now impugned, yeah.
Part of the,
See page 15, last portion, my lord.
para 23, yes.
Yes, liberty rests with the petitioner to approach the pollution board for seeking
Gujarat State Pollution Control.
Yes,
Yeah.
to seek revocation or go to NGT, my lord, and these observations will not come the way, etc. Now, I only want to state, my lord, on 5th of February, I have gone to them. That, my lord, representation is pending.
We can direct them to decide your.
Only one thing, my lord, till then the closure, my lord, should be in abeyance. Why should I be closed?
That part.
No, even if you decide in 1 week, my lord, your lordships consider a man who is not remiss on his own factory is not remiss, my lord.
You simply tell us that have you approached the state control pollution?
Yes, I have approached them on 5th of February. I have placed it on record. And I wanted a stay. That's why you mentioned to my lord the Chief Justice on Friday.
No, we can simply direct the pollution control board
Yeah.
to decide that matter within a week.
After giving me an oral hearing, my lord, I will show them this.
Of course.
Number. But till then, my lord, there should be no coercive steps. My lord, what is the advantage? I produce, my lord, for anesthesia. I give it to the government. I give it to all that. There has never been, my lord, a remiss position of this factory for 10 years.
You see, sometimes the harsh actions are required to be taken to convey a very stern message to everyone.
I understand that.
You can't play with the environment like this. That is only maybe.
But my lord, to paint me black because one black sheep may have been remiss is too harsh, my lord, for a closure. I employ 500 people, my lord. I have never been remiss. There is not a single instrument, my lord, equipment which is not installed. Consider, my lord,
They can consider the main matter.
just consider this, my lord. Every day your lordships have cases where there is affluent flowing from factories.
Operating a manufacturing unit at the Dahej in Brackett, Gujarat. The spent hydrochloric acid,
Yes, spent.
in bracket spent HCl, is generated by the petitioner's industrial unit as a byproduct. According to the petitioner, that spent HCl is supplied to an authorized actual user. However, on 29th January 2026, a tanker bearing number GJ-27-TG-6676 loaded with 34.170 metric ton empty of spent HCl is departing from the petitioner's industrial unit, a factory, on 30th January 2026. Was found to have thrown that spent HCl in Narmada Canal. This prompted the Gujarat Pollution Control Board
Lord, only for
take an action under section 33 capital A.
only one interruption, Lord. They gave me a show cause notice asking for a reply in 3 days, but without waiting for that, they closed me the next day.
We also closed one of the other side. The other entity where they were receiving HCl, we found that they have not received HCl. What happens is, for them, it's a byproduct. For another company, it is a raw material.
But Your Lordship may say it's an allegation. I don't admit that he has done this, he has done that.
Pollution Control Board is said to have found from Messrs. Sri Ramnath Chemical
Yes.
that the spent HCl was not received by them. The spent HCl in a roasted truck was not received.
Lord, we dispute this proposition. We dispute this. That it was diverted or that, my Lord, he didn't receive it. I dispute it.
Was alleged
I'll show it.
received by them. There is further allegation that it was thrown in Narmada Canal. Be that as it may, the Gujarat Pollution Control Board issued a show cause notice and thereafter has passed an order.
Issued a show cause notice for 3 days, but
Lord, they did not wait for my reply. They passed the order the next day. That is one breach.
Invoked its powers under section 33 capital A of the Water Prevention Bracket 33A2
Yes.
of the Water in Bracket Prevention and Control of Pollution Act 1974 and issued a closure order dated 3rd February 2026
to avoid grave injury to the environment.
on the ground of avoiding grave injury to the environment. That's what I want. The above stated order was challenged by the petitioner before the Gujarat High Court, before the High Court of Gujarat. However, the petitioner's petition has been dismissed by the High Court, while the impugned judgment dated 5th February 2026 with the following liberty. Reproduce para 23. Next paragraph. The aggrieved petition is before us. At the outset, it is pointed out by Sri Mukul Rohtage, learned senior counsel for the petitioner, that in deference to the directions contained in deference to the liberty contained in para 23 above, the petitioner has filed a statutory appeal.
No, my Lord. A representation.
Petitioner filed a reply to the show cause notice come
No,
representation.
actually, my Lord,
Sir,
show cause is now
revocation
over. I made a representation on 5th of February before GPCB. On 6th of February.
Has made a representation to the State Pollution Control Board seeking recall of
Yes.
Revocation, no, it's called revocation. Revocation.
Revocation of the closure.
Revocation.
seeking revocation of the closure order dated 3rd February
My lord.
2026. Yes, sir. That being so, we deem it appropriate to dispose of the special petition with the following directions, stroke liberties. One, the prescribed authority in Gujarat Pollution Control Board is directed to take an appropriate decision on the prayer or stroke interim stay made by the petitioner in its representation within a week. Please do. The interim order the interim order of any nature may be passed pending the final order on the representation, which may be decided. Do we need one order is sufficient?
No, dear Lordship, because that would mean that we have to pass some interim order.
Or not.
My Lord,
We will decide, but not finally one.
but for 1 week, please don't close it. That's all I'm saying.
To decide the representation within 1 week.
After giving me an opportunity, my Lord.
After hearing an opportunity of being heard.
Personally, yes.
The petitioner's representative,
Yes.
authorized representative. Next paragraph. The aggrieved party shall be at liberty to approach the National Green Tribunal. The there may be a separate prayer for interim directions before the National Green Tribunal, and in that event, such a prayer of the aggrieved party shall be decided by the tribunal as early as possible and preferably within 2 weeks, subject to the pending appeal, subject to the outcome of the pending appeal.
Good.
Please.
Good.
Obliged.
Item 44.
Please, Your Lordship. Your Lordship, I've been in custody for around 269 days, and similar co-accused have been granted bail.
But in your case, notice has not been issued so far.
Sorry.
That's what.
Notice, no. Fresh.
We have granted bail to your co-accused,
Yes,
but
that's
then we have to issue notice in your.
That's correct, Your
Issue
Lordship.
notice, trustee. Are you there?
I appear on advance notice, Your Lordship.
You are for the state.
Yes, please.
Then say, Madam, accept notice on behalf of the state of Chhattisgarh. We have already released the co-accused.
Yes,
Do you want to file reply or we can release him also?
We want to file a reply.
You want to file reply? Then do it by Friday. File a short reply. We have our next Monday.
Oblige, Your Lordship.
Counter affidavit to move issuance date with advance copy to content for the petition post to content.
Oblige.
May I please? This is also fresh. Now 9 months, 9 years, 7 months, I have completed out of a term sentence of 10 years. Well, the High Court says that period of incarceration is not the sole criteria. Well, if I'm going to complete the entire sentence while my appeal is pending, with great respect, my lords, it can't be that my appeal will be rendered infructuous as far as this is concerned. Please see the custody certificate, my lords, at page 446.
Well, your appeal is of 2020.
Yeah, my appeal is of 2020. Out of the sentence that is there, I have already undergone 9 years, 7 months. 10 years is the sentence that is imposed on me. 9 years, 7 months I've undergone. Another 5 months, 6 months, I would have undergone the entire period of sentence. Entire period of 10 years I would have undergone.
Do you know what's the hardest part about trading? Not the charts, not the strategies. It's all about the emotions. P&L green होता है तो लगता है कि थोड़ा और वेट कर ले, क्या पता प्रॉफिट्स बढ़ जाएं. और अगर P&L रेड होता है तो यही होप करते हैं कि क्या पता रिकवर कर जाए. But this never happens. Result.
How can it?
7 years is actual. 7 years is actual. 6 months. 7 years, 6 months. Then they was added a remission period.
Remission is available in this kind of.
Remission is
There are no
available.
remission. It has to be actual sentence only.
Is listed on 11th for hearing.
With
Penal
respect,
appeal is listed on 11th for hearing.
See, I thought to decide the appeal.
Why not an appeal for converting it to 302?
Because there is,
Huh?
I have filed an application
Yes.
regarding that.
But the victim has filed.
We have, that's also pending.
That, Mr. David,
with respect, but today there is no appeal.
there is an appeal.
There is no appeal. Please see the cause title. There is no appeal, my lord. For there is. Please,
No.
my
We
learned
are not
colleague-
concerned with cause titles, Mr. David. It's the victim here before us
No,
who's
if
saying
there-
has filed an
my lord,
appeal.
if there is an appeal, it would have been taken up with the same matter many.
But we don't wish to comment. Give the
then where is
number
the
of the appeal to Mr. David so that he is better advised.
I'm not, my lord, today,
Please, you get the number of the appeal under appearance.
Mr.
each
David,
appeal, my lord, with great respect, there is no
Out
appeal
of-
on this matter.
out of 10 years or so, whatever sentence that has been awarded by the trial court,
Yes, my lord.
you have undergone actual sentence of 7 years and 9 months or so,
Yes.
right? Less than 8 years.
Yes.
It's of
It
300.
is highly debatable whether an offense involving moral turpitude of such a nature,
Yes, my lord.
will you be entitled to claim any remission?
Yes, my lords, of course.
Anyway,
can claim
we
commission.
are not saying, we
Remission
are
is a-
saying highly debatable.
My lords, remission is available even in murder cases, but after 14 years, you have to undergo 14
Murder
actual
case
14.
can be, you see, murder case can be sometimes a simpliciter murder.
But this is a murder
The
case
two
only.
groups are fighting out of certain on momentary issues, sometimes without any intention, sometimes take place, or it can happen. There are several
The
circumstances.
remission policy of Delhi government is clear. This is a term sentence of 10
Anyway,
years.
that issue becomes academic in the sense, once the learned solicitor is pointing out that your appeal is coming for hearing
On 11th.
on.
11th.
Yeah.
It was listed
So
on
we'll
the
request the High Court, to take up your appeal on day-to-day basis. They are not opposing it. They will argue from their side. Prosecution will also extend full cooperation.
Victims appeal.
No, this is, I'm with great respect.
And
I have yet to come across
jail
a
in-
case where a person has undergone out of 10, with remission, with remission also 7 years, without remission also 7 years.
Yes.
And that
The-
no
yes.
suspension is granted to him.
Mr. Dave, the total period undergone by a convict is undoubtedly a factor that is kept in view while suspending the sentence. But why we suspend the sentence? Only when we are uncertain about the time that will be taken in the final decision of an appeal. Here is a case where the main appeal has been listed for final hearing. What is only is required to doubt to remove any kind of cloud on that certainty, we will request the High Court.
It was listed on third, as per the impugned order, it was listed on third, not taken up on third.
Why?
Because
Why
your
must not have been taken up? Because somebody must have pointed out that your assembly is
pointed
coming
it
before this
Nobody
court.
pointed it
There's
out.
a difference. There's a
No,
difference.
Lord, this is with respect, Manoj.
Mr. Dave,
This
Mr.
goes to Article
Mr. Dave,
21.
right from all high courts in this country, including the Supreme Court, we have two categorization of two sets of criminal appeals before us, where the accused is on bail. We do not grant out of turn hearing in those matters because we know that there is no crisis of liberty. Bail have been granted. But in these cases where we do not deem it appropriate to release an accused on bail, that's a separate set of category where the appeals are taken out of turn. If your is a case, 2020 appeal might not be ordinarily, it will not come as per turn in Delhi High Court. But because you are there, you have not been granted bail, that's why the High Court is according you out of turn hearing. And we will cement that, we will further request the High Court, making it sure that your appeal is heard.
Appeal, it may be heard.
Lord, another
Well,
thing.
just 1 minute, my learned friend.
Already
Please, just.
undergoing a life imprisonment in the second offense.
So what difference does
So
it
whether,
make?
my lord,
So I should not
it's
get
here
bail.
or not, my lord, doesn't make any difference.
Every time, the argument is even better. Now, please see if for a 10-year term sentence, suppose it was not 304 part 2, suppose it was 307, attempt to life 10 years I've got. Would it still be that I'm not entitled to remission?
We are not required to look into these aspects. We are not saying, you see, as an accused, you see, this is one country who is so proud of on rule of law that even the most heinous, dreaded criminals, we have been according opportunity of hearing. This country has followed the rule of law. This country has provided a fair trial, even to the dreadest anti-nationalist elements, even terrorists.
Assam was,
So even a person, as Solicitor is pointing out, a person who came attacked so brutally on the integrity of this sovereignty of this country, we even provided fair trial to him
the
also.
offense was seen by the world on television.
What does my learned friend? I am not listed in a Kasab matter. I don't know why my learned friend is on Kasab.
In
This is
your
not a
case
Kasab
also,
matter.
no, he is only illustratively telling that in the
This
worst
time
cases
link
also.
me to Kasab. What do I have to do? I was a
You have
sitting
to do
MLA.
nothing. You have to seek an assurance from the court of law that irrespective of the nature of allegations, irrespective of anything coming in media, you are entitled to a dispassionate hearing of your criminal appeal by the High Court, which will be decided without being influenced by here and there anything, which should strictly confine to the evidence on record, material on record. That's all.
So now, may I just answer one question which fell from my Lord Justice Bagchi? My learned friend says he has filed an appeal. That appeal is for necessarily enhancement of sentence. It can't be for anything else. It has to be enhancement of sentence or change, or that it goes under 302.
Why not? Why not? It's
It goes to
302 charge was framed against you, 102
I'm assuming against myself.
So there is a lesser offense on which you have been convicted. Why so to the?
Just bear with me for the submission.
Yes, you can bear with you for a lifetime, Mr. David.
The enhanced sentence could also be death in that.
May I just indicate why I'm making this submission? If it is my learned friend's appeal, it goes to DB. This matter is before a single judge. It's below 10 life sentence. Then it cannot. No, I'm saying if it is fixed on 11.
In appropriate cases, Mr. Dave, this sort of an appeal where there is a possibility of a appeal by the victim for enhancement, not a case for a division bench.
There's no point, Manoj, for 11,
Interact
for 11.
So nobody loses one appeal.
Nobody is arguing this. I don't know why the solicitor has not preferred any appeal in this matter. The CBI is sitting pretty.
This is not a case of any quorum non judice, please. These are all internal arrangements by the.
Are asking the High Court to expedite the appeal.
So therefore, in the case, suppose a division bench a division bench of the High Court, suppose prima facie feel that the appeal filed by the victim also should be heard along with your appeal. In that case, matter has to be listed before a two-judge bench.
So it can't be heard on the 11th in any case, since much submissions were made, it's listed on 11th, hear it on 11th, have it on day to day, the other side is saying though, it can't be heard, that's, I'm all pointing, the only thing I was pointing out.
Can be taken up on some other.
So, my lords, 10 years, assuming that he goes through his 10-year sentence, my lords, his appeal would be infructuous, and if their appeal is dismissed, he's undergone the entire sentence.
Kind of
without
whatever
bail.
doubts you have in mind about listing, that we will clarify here. Both sides.
I'm saying, my lords, if
Both
9
sides
years,
are
7
present
months,
before us, so
in 9 months, 7 months are not enough. If 9 months, 7 years are not enough.
As well as their.
We were not even charge sheeted in for murder by the CBI. It was a club trial, therefore.
We are not charging.
Look, may I just say,
Initial,
this,
the initial charge
So
sheet.
I'm only saying, my lords, 9 years, 7 months undergone, with remission, another 5 months I have to undergo. I will undergo that period. There is nothing else that is left, you know, whether the appeal is heard or not becomes an academic question.
No, no.
Only if their appeal gets allowed.
There is
Only.
no criminal appeal becomes an academic issue. Even in those cases where unfortunately the persons died while pending the criminal appeal, because the family is still entitled to seek vindication of innocence. If there is an innocent person falsely or erroneously convicted by the trial court. So there is, these are nothing to do, completion of sentence, anything, these are not the circumstances.
Out of 10 years, 9 years, 7 months in custody, or 7 years actual custody, is more than 7 years.
We appreciate your contention.
But
Therefore,
what
we request the High Court,
This is
request the High Court to decide your appeal.
If I had come in any ordinary case, my lords, I would have got bail. With respect, I'm just saying so, my lords. When it came, the other matter came before your.
Jail for.
Just 1 minute, my the solicitor is not, there is no notice is issued in this matter. Now, if I, because that other matter, when it came, we said that this is, you know, it fell from the Honorable Chief Justice that you are not released in that matter. Therefore, we are staying that matter, in the bail in that matter. When we come in this matter, the solicitor says, in that matter, you are in custody. So how does it matter? Somewhere I have to start getting bail, or I'm, my lords, going to be just in arguing my appeal or pursuing my appeal. And now the complaint is.
We have already explained that in a case of conviction
On merits also.
and pending criminal appeal, what are the parameters normally we follow on uniform basis in all high courts and including the Supreme Court.
Yes.
Where the accused is inside and has not been released on bail,
My lord.
he or she is entitled to an out-of-turn hearing of the criminal appeal,
Yes, my
so that at least before completion of the sentence, the matter is heard.
My lord.
That is the principle followed. In your case also, there cannot be any exception. You are entitled to whatever you are entitled to law, you must get it.
Yes.
Therefore, you are entitled to an out-of-turn hearing that the High Court is according. We will also make sure that you get it.
But that process is not available, my lords, because now the complainant feels that I should be convicted under 302. So his appeal first has to be.
Mr. Dave, for deciding your
EC 365.
for deciding your appeal, we cannot gag the right of a victim. If at all there is a right in law.
Mine also, my lord.
Yes, therefore balancing has to be done.
For 9 years, 7 months,
We are absolutely right to do, but there has to be a balance of rights.
I've undergone more than half of this actual sentence. Actually, I've undergone more than half, my lords. Kindly consider this. In which case, for term sentence, this is not a life imprisonment. Life imprisonment, I can understand the High Court has some leeway. Your lordship may have some leeway that it's a life sentence. There is no term there. But in a term sentence, my lords, your lordship always takes into account the period.
It is a term sentence of a person who has been convicted and sentenced to life imprisonment in another case.
Yes, my lord.
Isn't that a relevant consideration for
Possibly, but in
suspension
that,
of
when
sentence?
that matter came up, my lords, the same argument was there that please stay.
Certainly, one will color the other.
So, my lord,
If there are,
That's what I'm saying.
why do we speak of criminal antecedent? When it comes to a question of multiple cases against an individual, courts are generally circumspect in granting
same
pre-conviction bail.
Same incident. It is not a separate.
No, it's definitely not the same incident.
Exactly.
It's the motive.
Incident,
It's the motive.
Allow me to.
The rape case is the motive for this crime.
In this case, here the person died in police custody. Person died in police custody. I was
Two police officers have been convicted.
Yes, my lord. And I have been with 120B. I was in Delhi. Those are the findings. I can show you.
Let us not comment on the merits.
Mr. Dave, any argument touching the merits from your side will invite a reaction from our side unnecessarily. And you know this matter that unfortunately it's not that we are not sitting in ivory tower. We know that there is a media trial also going on, which we do not really approve. And the way Mr. Prachap outside the court, he goes to the media. If you are a counsel, you have no business to go there. Don't forget, I have saved you in profession. Your license would have been suspended, your exemplary costs were imposed on you by the High Court. I saved you thinking that you will believe in professional ethics. You have no business to go to media when you are appearing in a case here. If you find that you are indulging in this kind of drama, then you will face the consequences also.
Can I just say?
As a Chief Justice of India, I can't tolerate these things.
Let's kindly see what the other side.
You are arguing here, you are conducting a parallel trial outside the court. This is not acceptable.
I was just informed.
We are only warning you today. You take this warning in the right earnest. That's all.
Can I also say this, that please tell this to the other side also?
Right now.
What
They have
side? I never went and gave interview with the
Now,
other side.
we have conveyed our message, and anybody knowing that how I function, I hope that people will believe it and follow it.
May I just say?
Then may I only suggest?
Do not invite any
Let the
consequence.
DB
That's all.
take a call whether his appeal is maintainable or let the
The
DB.
other side also.
You have a right to oppose, he has a right to
No,
argue.
I'm saying let the
You will argue in court, that's all.
Because the division bench, since your lordships are asking for expeditious, let the DB first decide whether his appeal is any merit in it or not, then call for my appeal.
The way that you will argue before division bench of the High
Leave
Court,
that-
not before us.
Expedite, then I'm only praying, don't expedite this simpliciter, my lord, my matter. Because it will be tied up with the division bench matter.
Right up. The petitioner, say leave granted. The appellant is agreed by an order dated 19th January 2026, passed by the High Court of Delhi, declining his prayer for suspension of sentence and consequently release on bail in criminal CRLA number 539/2020. Declining his application under section 389 in bracket 3 CRPC, seeking suspension of sentence and so on. The above stated criminal appeal has been directed against a judgment dated 4th March 2020 of the trial court, by which the appellant was convicted for offences under sections 166, 167, 193, 201, 203, stroke 21, stroke 21, 212, stroke 323, 341, 304, 120 capital B IPC, and sections 3/25 of the Arms Act. We just make sure that correction in this section. He was consequently sentenced to undergo a rigorous imprisonment of 10 years.
Yes, my
10
lord.
years.
Highest is 10 years amongst all of them. The highest sentence amongst all of them is 10 years.
Terms, maximum of which
He
was
was a maximum tenure of, maximum RI for 10 years, though different sentences were awarded for different offences. Those separate sentences were awarded for different sentences, offences.
And all directed to run concurrently, my lord.
That's what I got. It seems that the appellant, besides arguing, besides making an attempt, a case for suspension of sentence and release of bail on merits, also vehemently urged before the High Court that he has already undergone an actual sentence of 7 years and 9 months out of the total sentence.
With remissions.
7 years, 6 months, 29 days with actual. My learned friend is not aware since I'm in custody, and 9 years, 7 months with remission. So 7 years and 7 years and 7 months of actual custody.
7 years or 7 months of actual sentence. Anyway, that's a matter of calculation.
No, it's there, my lord, at page
Next paragraph.
46.
The High Court has by the impugned order one more line. The appellant also urged that some of his co-accused had already been released on bail after suspending their sentence, while orders dated 22nd September 2023 and 17th October 2023. The
ঘরের সব জিনিস পাই সবচেয়ে কম দামে 2 ঘন্টার মধ্যে ডেলিভারি সাথে ডেলিভারি ফি একদম নেই আর শোনো প্রথম অর্ডারে 1 কিলো মিনিকেট চালও ফ্রি এই বাঁচানো তো আমার অধিকার ডিল শেয়ার টাকা বাঁচানো আমার অধিকার
The appellant is already serving a life sentence for the rape of the deceased minor daughter in a connected case, semicolon, that his previous application for suspension of sentence was dismissed on 7th June 2024, and there are no new exceptional or compelling circumstances, etc., etc. Next paragraph. The aggrieved appellant is before us. Next paragraph. At the outset, it is pointed out by Sri Tushar Mehta, Solicitor General of India, representing the Central Bureau of Investigation, that criminal appeal, criminal LA number 539/2020 of that the appellant's criminal LA number so and so is now listed for hearing before the High Court on, what is the date, Arvind?
11th.
On 11th February 2026. He thus submits that the High Court can be requested to take up that appeal, to take up and decide that appeal on out of turn basis. Can may be requested to take up and decide that appeal on merits, on out of turn basis. Next paragraph. At this juncture, counsel for the victim states that the complainant side has also filed an appeal challenging the trial court judgment dated 4th March 2020 on various grounds, including on the question of quantum of sentence. Next paragraph. In criminal LA number 539/2020 and decide the same as early as possible, but not later than 3 months, but not later than 3 months. Next paragraph. As regard to the criminal appeal, if any, filed by the complainant party stroke victim, we grant liberty to the appellant in that case to approach the High Court for taking up of that appeal to for hearing. Full stop. The High Court is requested to firstly take up that matter within 1 week and subject to the objections re maintainability, etc. If the High Court find that the said appeal to All issues can be decided together. Huh? They will tell. So re-maintainability, etc. Comma. It will be in the interest of justice that both the appeals are heard and decided together. Heard and decided together. Understood. If such a recourse requires the change in composition of bench for for deciding criminal LA number 539 of stroke 2020, comma, Honorable Chief Justice of the High Court will do the needful in this regard. Anything else you want?
There are 8 connected appeals which have to be decided with this 539 of 2020. They are all co-accused. So it's not my appeal. There are 8 connected appeals.
Connected appeal of other countries.
With 539 of 2020, the present appeal. So they all have to be decided together.
If there are, next paragraph, if there are other connected appeals, those two also be taken up and decided along with the lead appeal, along with the lead case.
Then if it is not decided in 3 months, my lords, then where do I go?
Yeah,
So then I'll
it
be
is
back
not-
for.
Incidentally, I am not retiring in 3 months. My brother or both in any case will retire after me. So then nothing is that unforeseen circumstance we should see.
I have hope, my lords. I'll be back before your lordships. Grateful.
Does they also?
Issue notice.
Accepting.
Advance.
Would you like to accept? Notice?
Accepting.
Then so accept notice. Counter affidavit if any be filed within 1 week. Counter affidavit, only 10 days.
2 weeks.
2 weeks. 2 weeks post the matter on so date for further consideration.
Get me that.
भी क्वेश्चन इस वी में आएगा extra 6
23.
any comment Twenty-three. We just follow 23. Lordship, it's specifically refer for the prayer.
This writ is not maintainable. Kindly have the prayers, my lord. If he has a grievance, then he can approach the High Court, my lord.
Uniform standard operating procedure governing pleasing.
And that is already on.
The council, either prime minister. How can such a direction be issued? Sir?
Lordship, the thing is, after the last
It has to
order,
be decided on case to case basis.
Lordship.
Where you find that yes, freezing is absolutely unwarranted, you can go, the court can interfere. And why should we entertain this?
Lordship, there is a subsequent development after filing of this order on a 16 January of the last order. Delhi High Court also issued this similar.
That matter is also today.
That's a suo motu petition.
No, is it listed today?
Yes.
Okay. We'll hear it after.
Yes. Lordship, just consider the order passed by the Delhi High Court in a similar matter, where the Home Ministry come with the standard, they've already issued some SOP. So if SOP is there, then just let it be.
High Court of Delhi High Court judgment before.
My lord, I am also in the matter 47, similar matter, my lord.
And then one more
But
part.
Judicial High Court is UP, my lord, Allahabad High Court.
My lord, these accounts are being frozen across the country, my lord, and there are so many matters.
Because
And there is urgent need, my lord, to intervene and
you
to.
want us to uphold this freezing of accounts. You want
No,
us
my
to
lord,
uphold.
I am saying
Don't invite further
unfreezing
trouble.
should be a mechanism, and the 106 is being violated, 107 is being violated. Magistrate order is required, my lord.
Having heard and consulted.
Kindly issue notice in this matter. This is very urgent, my lord.
Judicial Solicitor of India on behalf of the respondents, Union of India, we see no ground to entertain these petitions. Stop,
Multiple states are doing in the same account, my lord.
accordingly dismissed. However, with liberty to the aggrieved persons to approach the jurisdictional high courts on case-to-case basis.
Lordship, before concluding my.
No,
Lordship, I
that's
just
no
want to
question.
point out one thing.
Everything coming under 32. As if there is no other.
This is being misused by the law enforcement authorities quite a bit.
Absolutely.
Kindly, it is
It is high
required, my
time
lord,
that they
to.
must do something very.
I am in Mumbai. My account is frozen for
That's
4,000
the
rupees from
difficulty.
Jammu Kashmir, my lord.
Then go to High Court, approach the High Court.
So that's
Do
the
not know.
concern of the entire petition, that if I'm standing in.
There has to be
Uttar Pradesh,
proportionality,
then
my lord.
Complaint filed
If
before.
every person like this start coming in the 32, what will be the end?
More than
High Court,
multiple
you are
states
not
involved.
remedial.
No, my lord's intervention and the law has to be settled, my lord.
Yeah, we will, don't worry, we will do that. We are right now.
Kindly issue notice and
Sorry.
allow some relief, my lord.
Question of issuing notice in these matters. Where you are suspected to be involved, where is the question of issuing guidance at your instance?
47, this is my customer. It's a consumer matter only, 4,000 rupees.
Yeah, thank you very much. Thank you.
Kindly have a look at page 60. Just 1 second, my lord.
If you don't see anything, please go to High Court and show.
It will be,
Go to
no,
High
my
Court
lord,
and-
can give just see my customer is there.
Yes, yes.
And they are misusing this. After 8 days, they are filing this complaint.
The banks are hands in glove. This is what the report shows. We don't want to say anything because it will cause serious prejudice to all of you. The banks, their officers are hands in glove in the matter of digital arrest and the cyber crime of looting this money. It's not extortion. It's a
My lord, but I am suffering.
brazen loot.
Yes, Lordship.
Bank might be involved, but I am suffering, my lord.
Lordship is absolutely right.
What
There is
can
a
we
bank
do?
are involved, but in this case, those are not directly compared.
Then please go to, that's why you said case to case basis. If you are a victim, you will tell the court. If you are
concern, Lordship.
if you are clean hand, you will tell the court that I have nothing to do with, court will pass an order.
We are not concerned with the transition itself.
Thank you,
And
thank you
therefore,
very much, thank you.
Lord, there is no FIR, nothing, just the misuse of the I4C mechanism.
Yes, yes.
Kindly issue some guidelines on this for the defreezing, my lord.
We will not issue right now, we will see at the time of final hearing.
And my entire business is gone, my lord, because my account is completely frozen, my lord. I am a small time professional.
Therefore,
Look, may I request that 24 may be stood over to tomorrow or any other date? There was some misunderstanding. I thought this was the matter when notice had been issued and
next Monday, Mr. Singh.
there was some miscommunication on my part. Can I request if your lordship?
No, you wanted to place on the additional
We
document.
placed those, but I thought this was the matter when notice was issued. I mixed it up because no reply was there in that matter. So if your lordship could keep it either tomorrow or Friday, or whichever date your lordships.
Friday, we are avoiding Friday.
Or Monday, there was just some miscommunication on my part.
Want to next Monday, we can take.
We have already filed the documents. I had some misunderstanding about which matters listed.
We will say like this.
Monday, if your lordship would keep it.
Mr. Singh and Senior Counsel informed that additional documents have been filed. The registry directed to tag the same, post the matter for further consideration on Monday.
Deeply blessed.
Transfer करना है.
May it please, madam.
Item 26.
26, your lordships have already.
We will allow that matter.
Despite your lordship's order, every day they are filing
They are
cases.
still
in
filing.
Kolkata, my lord.
Then if we issue notice and you remind us, then we'll impose some exemplary post.
I'm grateful, my lords.
How much the amount in dispute?
My lords, the loan amount was 1 crore, out of which we went to DRT and we paid substantial amount.
Issue notice to the respondent, returnable on so-and-so date. The respondent bank will also show cause as to why contempt of court proceeding and exemplary fine cost be not imposed on it for filing complaints at. The complaint has been filed which place?
My lords, Kolkata, my lords.
Huh?
Kolkata.
Has been for filing the complaint at Kolkata instead of Nampalli,
Hyderabad.
Hyderabad.
Correct.
Basti.
Till then, the proceedings may be stayed, my lords. Till then, the proceedings may be stayed, my lord.
You serve them next week. What is the next date?
My lords, the next date I have to verify, my lords. I have to verify.
Meanwhile, further processing before the Calcutta so shall remain stable.
I'll do that, service, my lords.
Bengal SI. Item 48.
Great.
Yes, my lord.
Huh.
My lord, may it please your lordships.
We will take up along with those matters. We will take up along with other matters. Everybody now start filing separate cases. We take up along with the other cases. Coming 2 o'clock.
My lord,